Hello folks, welcome to Legacy IAS Academy. In this video, we will be discussing this week's current affairs from Polity and Governance. Okay. The topics for the day are CIC exemption of BCCI from the RTI Act of 2005, Janani platform launch for maternal and child health care, with ordinance, Supreme Court judge strength increased from 33 to 37. Urban local bodies, the missing third tier of Indian federalism. And last topic, World Meteorology Day 2026. So these are the topics that we'll be looking into today. So we'll start with the first one, CIC exemption of BCCI from the RTI Act of 2005. Now first, let me explain it like a story to you. What is it means? See, your CIC, Central Information Commission, compared to its earlier verdict, has changed what it was telling about your BCCI. What was it? Now first let's discuss earlier. Your Central Information Commission held that BCCI was a public authority. But now it has held that your BCCI will not come under the proper definition to call it as a public authority. Meaning what? See, there is something called RTI Act of 2005. Yes, it promotes transparency, accountability, okay, wherein your individuals can access any information they want from public authority. Now, this information called, okay, public authority is applicable to anything and everything that comes under the definition of state under Article 12, right? There will be, so for all your state definition ka coming bodies pe, they will come under public authority. Certain private bodies will also be applicable under Article 12. Let's say if they have been receiving substantial funding from government, okay, or something that will make it in, let's say, a government aspect, that time it will come under. Otherwise, just for mere private bodies which has no substantial funding, it won't come under your excuse me, public authority. Okay, so it comes under mere private body. Another important aspect that they are trying to speak about is your BCCI was not registered. Okay, now look, listen to this properly. Was not registered or was not created by either an act of parliament or by an act of state legislature or by any executives. Rather, it is a private body which is registered in Tamil Nadu under the name of trusts. So under all aspects, it is not coming under the definition of public authority. So which means RTI will not be applicable to it. Now if you see, many Supreme Court verdicts are also there wherein they will tell that even though it functions a public duty, doesn't automatically make it a public body. First thing, unless and until you receive substantial amount of funding, let's say more than 50%, you just can't claim it as a public body. Just because you get some tax exemptions or indirect government favors also does not make you a government body or to be eligible under Article 12. Okay, look at this. Your CIC ruling in 2024 was BCCI is not a public authority under RTI Act of 2005. So this, whatever it has told now, it has gone opposite to its verdict in 2018 where it claimed that BCCI was a public authority. So as of now, BCCI is excluded from your RTI, meaning your citizens cannot seek information with regarding to your BCCI. So this raises questions on your accountability. Okay. Now if you see with respect to RTI Act of 2005, look at this. The whole point of RTI Act was to bring in a sense of accountability, yes, transparency. These are some of the key terms with respect to your Right to Information Act. Also, this is what is your important aspect under Article 19(1) of A, fundamental right under freedom of speech and expression. So, where does this RTI Act apply to? Means anything that comes under the definition of state or Article 12. So, central and state governments, public and constitutional bodies, statutory bodies. So, it will not apply to private entities, okay, or any other autonomous body unless and until Section 2H of RTI Act is applied, okay. So, what is Section 2H? Here is where they define what is a public authority. So, an institution will be called as a public authority if it is established by constitution, parliament or state legislature, government notification or order, that is your executive action. Was your BCCI established by any of this? No, it was did by a private trust registered under in Tamil Nadu. Second, substantial financing. That is, like I told, more than 50% of funding is not coming for your BCCI from your government or controlled by government, either direct control or indirect control. So when both of these conditions are satisfied, then it will come under definition of public authority under Section 2H. But your BCCI does not come under this, is what your CIC stating. Now, on what grounds did CIC tell BCCI is not a public authority? First, it told that it is a private body is because it is registered under Tamil Nadu Societies Registration Act and it was not created by either parliament or state legislature, or it was not formed by executive conditions. Second, there is no substantial financing. Just because you get certain exemptions from tax does not amount to government funding. This is very, very important with respect to substantial financing. Where is majority of BCCI revenue coming from? IPL rights, sponsorship, broadcast, these kind of things. So tax exemptions does not mean government funding. Okay, so BCCI is financially independent. According to this condition, it is not created by either constitution, parliament, state legislature or executive action. Third, the officers of BCCI are not appointed by government and they are not involved in the daily administration, nor is the state funding for its operations. So there is no deep state control. On all these three grounds, it is seen that your BCCI is not a public authority but rather a private body. Okay, look at this. Alongside this, they have also taken, okay, a lot of your judicial judgments also into consideration to come to this conclusion. What is that? See, first one is Thalapalam Service Cooperative Bank versus State of Kerala, in which they have told if a body receives indirect benefits, that does not automatically mean that it is a public authority. Understanding? Mere government aid or concessions does not mean it is a public authority. Your substantial funding has to be there. Second, in Zee Telefilm Sources Union of India, they held that BCCI does not come under the definition of state under Article 12. Next, Dalco Engineering versus Satish Prabhakar. In this case, in order to call a body as, let's say, your private, that is public authority, okay, you have to have substantial amount of funding, then only it will be seen, not mere exemptions. Next, under BCCI versus Cricket Association of Bihar, see, they have told internal governance reforms is needed within BCCI. Okay, for your Lodha committee, reforms had submitted for increasing transparency. Okay, this was partly accepted, but they did not declare that BCCI is a public authority. So, taking your judicial jurisprudence also, we can tell this. So, if a particular body is supposed to be called as a public authority, then there should be substantial state involvement and it should be a body created by either constitution, parliament, state legislature, executive authority. So, because we brought about Lodha committee and law commission report, both have favored transparency reforms in BCCI. Lodha committee report also brings about your concept of age and tenure caps for officials. Okay, but if you see Lodha committee report, it was just recommendations. Your CIC also further goes on to tell that Lodha committee reports are just recommendations. These should not have precedence over the order. Law Commission also held that BCCI should be brought under your RTI framework, but again CIC is telling both these recommendations are advisory in nature. They cannot override the provisions of your RTI Act of 2005. So, CIC is making sure that government control does not automatically ensure fairness or efficiency. Okay, so this is where they are trying to bring about your changes. That is why it is changing its earlier stance of your BCCI being a public authority to now it is a private body. So, if you see, there is a good amount of aspects as to whether it should be brought under RTI or not. One of the main things we cannot, okay, move ahead from is transparency and accountability are the key cornerstone in good governance. Understanding? So, when public interest is also there, a lot of aspects has to be considered from your RTI also. So, as of now, what can we be the takeaway? Your BCCI does not qualify under substantial funding also. It is not created by either constitution, parliament, state legislature or executive. So, because of that section 2H definition wise, BCCI does not come under your public authority but rather a private body. So, CIC reversed its 2018 order and they also held that Lodha Commission report or Law Commission ka report cannot override RTI Act. Okay. So, let's look at a possible prelims question from this topic. Okay. Look at this. Consider the following statements regarding the recent CIC ruling on the BCCI and RTI Act of 2005. The CIC held that BCCI is a public authority under section 2H of RTI Act. No, they held that it is not a, okay, it is not a public authority, rather it is a private body. So, first option is wrong. Tax exemptions and statutory concessions were considered as equivalent to substantial government financing. See, we said as not equivalent, okay. When we tell equivalent, that means it goes wrong. Concessions or your exemptions should not be seen as government funding. So second statement is also wrong. In Z Telefilms versus Union of India 2005, Supreme Court held that BCCI is not coming under the definition of state under Article 12 of the Constitution. This is correct. The RTI Act applies to private bodies only if they satisfy mentioned conditions under Section 2 of H. Correct. So the correct options are 3 and 4 only. Next topic, Janani. Done? Okay, look at this itself. So this Janani platform, which is launched for maternal and child health care, is by Ministry of Health and Family Welfare. Why is it? To strengthen maternal and child welfare. So what is it trying to do? A longitudinal health records of women in your reproductive age. All the things with respect to their reproductive age, let's say from preconception, conception, what appointments they're supposed to go, what did they miss, what is the nudge they can provide, and also you provide a longitudinal service, and also you will flag your high risk pregnancies, right? All of these are provided in one particular medium. Okay, so Janani means journey of antenatal, natal and neonatal integrated care. What are you trying to provide? A digitization of your maternal and your child health records. This is done by your Ministry of Health and Family Welfare. Okay. So the ministries become very, very important. You have to keep a tab on ministry. Now they can easily make it confusing like Ministry of Women. Yes. So it is not Ministry of Women, it is Ministry of Health and Family Welfare. Now, why is it in news? Your Ministry of Health and Family Welfare launched Janani platform. What is it? It is for digital integration and real-time monitoring of maternal and child health care. Okay, it is the upgraded version of RCH portal. Again, your reproductive and child health. So this Janani is a service-oriented digital platform where all the health records of the women in reproductive age are kept and tracked. Again, why? Because in case if it's a high risk pregnancy, what are the visits they missed, all of those to be considered. What are the objectives of your Janani platform? Means continuity to be provided in maternal and child health care. In which areas? Antenatal care, delivery care, postnatal care, newborn care, family planning. From the time you conceive to what and all, let's say you have to have your supplements, or what are the health conditions there while the child is born, or whether is it a high risk pregnancy, after the child is born, what vaccination has to be given to them, okay? And also with respect to family planning, all these will be considered, okay? So how are they giving this? Means through your QR enabled maternal and child health cards. So you will have a digital mother and child health card, which will be easy for portable and verification, which means throughout India it is applicable, even if you are a migrant worker, okay? This also gives automated alerts on high risk pregnancies and what timely intervention can be done, okay? All these will be there. So, what are the key features of this CFEC? Again, they have real-time dashboards where they can supervise and monitor so that a better accountability will be there. Next is due list generation as to whether any missed services, let's say you are supposed to come to a particular scan but you have not did, and that has a follow-up concept. And throughout India, it is a pan-India portability. It can be tracked throughout the states, okay? So this will help very much for your migrant workers, women, okay? So registration, How will you register with respect to IDs of ABBA ID card under Ayushman Bharat Digital Mission? Okay, your Aadhaar and your mobile number. You can also authenticate through your OTP verification or biometric authorization. Okay, Janani is also integrated with your UN. UN is universal immunization. Similar, like we had something called as COVID, remember during your COVID pandemic days. So same like that, UN for your immunization program. Alongside that, it also has Poshan Abhiyan integrated with your National Nutrition Mission. Okay, so they will also track digital immunization, real-time vaccination record for your child, and nutrition and maternal convergence with respect to anemia, malnutrition, mother-child nutrition with respect to your national nutrition. Okay, so keeping both in track, that is nutrition as well as vaccination or your immunization. So if you say what is the achievements up until now with respect to your Janani platform, first and foremost, more than 1.34 crore beneficiaries are registered, 30 lakh plus pregnant women are enrolled, 30 lakh plus maternal and child health cards has been generated, 1 plus lakh biometric verification has happened in your Janani platform. So, what is the importance or significance of this Janani platform? It gives a complete track of maternal health cycle from antenatal, that is before birth of a child, to after birth of a child, and it has a real-time monitoring, which means timely intervention makes all the difference. Okay, better service delivery, digital health governance is there, which means you can make policies based on as to why still maternal health, deaths are happening, or why neonatal deaths. So you can make sure the policies are targeted at real time data. Okay, so it will improve the health standards based on the outcome based. So what can we do going ahead? First and foremost, like we said, ABBA ID card is a unique digital health ID under your Ayushman Bharat Digital Mission, a reproductive and child health program where the services are specifically targeted at the section of maternal and child health care, and with the universal immunization as well as national nutrition. Okay, all the issues that can come from conception, before conception, during, after, all these things are dealt with. So what can we do? Deepen ABBA integration, bring in your AI based risk prediction, and also link it with your health and wellness center, okay, or your primary centers, right? So this should be the way forward going ahead. So let's see one possible prelims question from this. With reference to Janani platform, consider the following statements. It is an upgraded version of reproductive and child health portal. Correct. It enables tracking of antenatal, natal and neonatal care. Correct. It uses QR enabled digital mother and health cards, child health cards. This is also correct. It has been developed by Ministry of Women and Child Development. No, it is not Ministry of Women and Child Development, it is Ministry of Health and Family Welfare. Okay, so this becomes wrong. Correct options are 1, 2 and 3. That's why you have to keep a good look on the ministries. It is very easier to confuse here. Next topic, with ordinance, Supreme Court judge strength increased from 33 to 37. Write down, write down. Now, look at this. The Union Cabinet chaired by Prime Minister Narendra Modi has approved the proposal for introducing Supreme Court Amendment Bill. Okay, but here if you see, they are trying to strengthen the judiciary. Okay, by strengthen the judiciary, we have multiple things that we will be discussing. Just look at this. So, through an ordinance, the Supreme Court judges or the number of judges in Supreme Court will be increased from 33 to 37, excluding Chief Justice of India. Including Chief Justice of India, it will be from 38 total, okay, because Chief Justice of India was not included, no. So, this is to be brought in. See, first and foremost, why exactly the increasing in the number is called as strengthening of judiciary? See, post your COVID, there has been a huge pendency of cases. Lot of e-filing has also been there. Okay, so unless and until you do something about this case backlogs, okay, it is not going to solve, and one of the main reason is because of lack of your fillings. There has been lot of judicial vacancies, not just in Supreme Court but also in your High Court and subordinate courts. So, increasing the or decreasing the vacancies and increasing the hiring either through collegium system or the suggestion or recommendation has been to create All India Judicial Services under Article 312. Okay, so wherein you want to make sure, see, the prime aspect is justice delayed is justice denied. If we have to go towards the concept of access to justice should be part of your right to equality, your right to life, then we have to make sure these kind of administrative issues have to also be resolved. And alongside that, we have to bring about a good ADR mechanism. Yes, so all of this becomes important with respect to your judiciary. So as of now, if you see the judges, the strength, there are 33 judges excluding Chief Justice of India. Now, through this ordinance, it will be increased to 37 judges excluding Chief Justice of India. Including Chief Justice of India, it will be 38. So, this is an ordinance. This change we are trying to bring about is through an ordinance. Ordinance issuing capacity is there for your president. Understanding what is an ordinance means we can consider it as a temporary law making power given to the executive. Okay. Now, when we say temporary law making power given to the executive is called as ordinance, that means these have to be used in certain circumstances. Or in rare conditions, not as a usual exercise. Meaning what? When is this certain circumstances or rare circumstances? When either one or both the houses are not in session, at that point of time you will pass an ordinance. By you, it is the President of India. So, the law passed so-called through an ordinance has the same effect as that of a law passed by the Parliament, but this is not of permanent nature. Meaning what? Once the house convenes back, okay, within that 6 weeks it will expire or lapse, or even before the term president can recall that, okay, or if the house disapproves it, then it will end, okay. So, your ordinance making power of precedence is under Article 123, okay. Okay. The act in which the number, this ordinance which changes the number of judges to 33 to 37, excluding Chief Justice of India, brings about a change in Supreme Court Number of Judges Act 1956, where it will amend, okay, Section 2 of 1956 Acts, which is speaking about the number of Supreme Court judges. So, Article 123 is ordinance making power of President. When can your President make an ordinance? When Parliament is not in session. If at all any immediate unforeseen situation expresses at that point they have to pass a law, this is where they will use. So this ordinance so passed has the same effect as that of a parliamentary law. And is ordinance subject to a judicial review? Yes, ordinance is subject to a judicial review. Okay. So, does it mean President has discretionary powers in passing your ordinance? No. Here is where we have to again look into Article 74. President acts on the aid and advice of Council of Ministers, and that aid and advice is binding on the President. Okay. Even though it is issued by President, it is actually to be your Union Council of Ministers or Cabinet. So, what is the duration of the ordinance? It is valid for 6 weeks after your up until your Parliament reconvenes or reassembles. If both houses disapprove or President himself withdraws, that time also it can be removed. Okay. Now, ordinance making time, again important thing like I told you, it is a temporary law making power. Once passed, the ordinance has the same effect as that of a parliamentary law. So, this temporary law can become a permanent law if the Parliament, after reassembling within 6 weeks, passes this bill, that is passes this ordinance, then it becomes a permanent law. Okay. Then one more thing was, in Krishna Kumar Singh case, judiciary held that constant repromulgation of ordinance or bypassing your order of your Parliament is considered, okay, as unconstitutional. So, with respect to ordinance, can it amend the constitution? See, think of it in this way. Ordinance cannot do anything that your Parliament cannot do. Understanding? This is the most simplest aspect. So, President acts on the aid and advice of your COM, which is binding on them. Ordinance is subject to your judicial review. Some of the judicial cases, if we see with respect to R.C. Cooper versus Union of India, where they held that ordinance is subject to judicial review, same like your parliamentary acts. A.K. Roy versus Union of India, they said even the President's satisfaction is reviewable, that is where it brings about your judicial review. Krishna Kumar Singh versus State of Bihar, continuous repromulgation of ordinance in order to bypass your Parliament's power is considered as unconstitutional and void. Okay, same is with respect to your DC Vadva versus State of Bihar case. Constant reissuing of ordinances is unconstitutional and void. Why do we need to increase the Supreme Court strength? Because there's more than 93,000 plus cases pending. Post your COVID pandemic, there is a high rise in your e-filing of cases. So, faster justice delivery is needed. Like I said, justice delayed is justice denied. And also, you have to expand the jurisdiction on the type of the cases also. For example, constitutional matters, PILs, commercial disputes, service matters, federal disputes, electoral litigation, privacy and technology, climate litigation. So, there are various types of cases also increasing, which needs an increase in the judicial power also. So, if you see the historical amendments, your 1956 Supreme Court Act of 1956, where they have been increasing the number of judges. So, 2026 ordinance also brings about a change in this original act only. Okay. Over the years, we have been increasing with respect to the number of Supreme Court judges. So, post this ordinance There is one Chief Justice of India and 37 other judges apart from Chief Justice of India, that is Supreme Court judges, which makes the total strength to 38. Okay, so what is the significance of this change? More the judges or more benches, reduced backlog, okay, then also access to justice will be increased, future jurisdiction with respect to your technology, climate, federal matters, all of this will be looked into. See, way forward, just increasing the judges alone will not strengthen your judiciary. You have to also increase your high court judges and your subordinate court judges where there is huge vacancies. And also you have to set up, establish a strong ADR mechanisms, and you have to digitize and expedite the cases listing very fast, and also creation of a all India judiciary under your article 312. So let's see a possible prelims question from this topic. Consider the following statements regarding ordinance making power of the president. An ordinance can be promulgated only when both the houses of parliament are not in session, when either one or both the houses are not in session. Ordinances have the same force and effect of law passed by the parliament. Yes, this is also correct. An ordinance must be approved within 6 weeks of reassembly of parliament. Yes, this is correct. This is correct. This is wrong. The Supreme Court has held that ordinances are beyond judicial review. No, Supreme Court has held that it is within the ambit of judicial review. Okay. So, correct options are 2 and 3 only. Next topic, urban local bodies, the missing third tier of Indian federalism. Done? Right. Done? Urban local body. See, first and foremost, this issue is not something that is very new. From your Nehru point of time itself, it has been observed that your urban local bodies were not being as effective. So what they started eventually was trying to give more autonomy, etc. Eventually, with the coming of 73rd, 74th constitutional amendment, it was further strengthening democratic decentralization. Okay. Now, as this kept on going, right, the concept of your local planning or your, let's say, Panchayati Raj system or your municipalities, all of this had to be furthermore strengthened and it was put under your state list. But in reality, in theory, what we see is different compared to what we see in reality. In many places, if you see, for example, let's say, your local bodies, okay, or your local governance bodies, if you see, rural areas pe we have Panchayati Raj system in 3 levels, your Gram Panchayat, okay, your Block Panchayat, Zilla Parishad, and with respect to your urban areas, if you see, we have Nagar Panchayat, Municipal Council, Municipal Corporation, right? In this, if you observe, there is not uniform development with respect to this local bodies. Okay. Why? If you see, certain municipal bodies do not have adequate financial experts, funding, okay, or technical advice or expertise. Okay. And majority of the staff are still appointed by your state government only. And also, if you see, 0.3% of the GDP is what they are raising. That is, their own amount of financial resources has been very less. See, if you see the point of time from your, let's say, creation of urban local bodies to your present time, center has raised taxes, state has raised taxes, but that is not the same case with your urban local bodies. Okay, so they suffer from the shortage of funds. They have to rely on your state and central governments for funding. If this is one thing, majority of the plans, for example, let's say Amrit, Okay, all of these plans are still implemented through a top-down approach only. The whole point of urban local bodies itself was your democratic decentralization or bottom-up approach. But still in India, many a places and many a cases, we see top-down approach only being followed. Okay. So, we are going to be debating on as to how your Indian federalism is extending to the third tier. So, we have federalism pe 3 tiers India has: center, state and local bodies. These local bodies are even coming under your state list. This constantly has been called, okay, by your Arvind Subramanian, who is the former chief economic advisor, urban local bodies as the stepchild of Indian federalism. Okay, so why exactly is this being told and why this seems apt is what we will be seeing in this. So, your urban local bodies have been established under your 73rd and 74th Amendment. 74th Amendment is your 73rd Amendment is your Panchayat Raj institution. 74th is your urban local bodies. In 73rd Amendment, we are looking at rural local governance through your village, block and district panchayat. Gram Sabha is very strongly empowered here. Here we have Nagar Panchayat, Municipal Council and municipal corporations. Based on the, here the distinguishing is based on the population. Okay. Now, what is the structure of local bodies in India? If you see, in rural areas we have Panchayati Raj system, we have village panchayat or gram panchayat, block panchayat, district panchayat. We have over more than 2.5 lakh gram panchayats. In urban local bodies, we have Nagar Panchayat, Municipal Council, Municipal Corporation. We have more than 4,000 plus urban local bodies in India. So what are the functions of these local bodies? Water supply, sanitation, roads, public health, urban planning, civic services. So certain topics are taken, created, and this list is to be transferred for your local bodies. For example, if you see for your urban local bodies, 18 items are to be placed. But in many states still, those items are not yet transferred from state list to your local bodies. They are still there in the state list itself. Okay. Why is this local bodies excluded from your debate of federalism? Largely, if you see, the issue is between center and state with respect to GST disputes, fiscal devolution, governor issues, okay, wherein the objective of your panchayats or municipalities will not even come in here. Next is state government dominates over your control of commissioners, especially with respect to, if you see areas such as Delhi, the severe air pollution, okay, this shows how fragmented, okay, your municipal bodies are, and also majority of the posts are appointed or they are put into place by your state only. So they have no control over their staff. Weak fiscal capacity, again their own tax revenue is very less compared to your state and center, and they have to rely heavily on the state and center. Administrative dependence also, again the staff which are placed are under state cadres, okay, so because of that they have very limited autonomy. And if you see under your 74th constitutional amendment, the 18 items which are to be transferred are not yet completely transferred in many states, okay, so complete decentralization is not something that we see. Your schemes such as Amrit, okay, all this are having top down implementation still and not your bottom up implementation. There is also issue of your structural challenges, where in your colonial legacy also there was not a very strong decentralization that was created. right? And that continued post your independence too, where they have, the local bodies have no power of recruitment, transfer, promotions, that is largely dependent on your state governments. Alongside, if you see in the whole of your local bodies, less than 10% of workforce is there in your local bodies, the compared to your USA or China, which is having a comparatively higher workforce in the lower levels. And also the municipal revenue contributes to only 0.3% of GDP, right? And there is very less public expenditure also with respect to your local bodies, right? And this reduces the autonomy and further reducing the accountability. So if you see, these are few of the reasons where your urban local bodies, or in general if you see, your decentralization is taking a hit, or the apt way of calling it is the stepchild of Indian federalism, is because of these. So we have certain aspects such as your e-Gram Swaraj, where we bring in digital governance in panchayat for planning, budgeting, accounting and real-time monitoring. Then we have smart cities mission, okay, which is for your urban governance, for creating integrated command centers. Then we have Swamitwa scheme, which is for property mapping based on your drones. So this will make sure your rural property ownership is secured and reduces land disputes. Okay. So if we see the certain failures or fragmentation of municipalities, or there is no proper holistic control, we can see examples of your Delhi pollution crisis. Okay, multiple agencies are looking into this creating a fragmented governance. Your Bengaluru's traffic congestion is showing how poor urban planning and rapid expansionism is affecting. Next is your Chennai flood vulnerabilities. Okay, then your Mumbai's slum growth. All of these showcases the same thing, that is your lack of urban planners, financial technical experts and low institutional capacity. All these scenarios ke liye we can give this as an example. Okay. So what does it lead to? That federalism properly is there only in center and state, and as it comes down, it is reducing, which is leading to poor urban planning, fragmented administration, and it is creating a deficit in the democratic processes, and local representation is becoming weaker, which reduces citizen accountability. Okay. So 73rd, 74th Amendment, yes, has created democratic decentralization, but it still remains the weakest tier of all the Indian federalism's three tier. We'll see one possible prelims question from this. Consider the following statements regarding urban local bodies in India. The constitutional status of urban local bodies was granted through 73rd and 74th Constitutional Amendment. Correct. Municipalities in India have significant control over recruitment and service conditions of their employees. No, municipalities are not having it. It is rather the state governments are having it. Okay. Next, urban local bodies generate a substantial portion of their revenue through their own taxation resources. Substantial portion, no, they are not generating substantial portion. Understanding, they are heavily dependent on your states. E-Gram Swaraj is a digital governance platform for Panchayat Raj institution. Correct. So correct options are 1 and 4 only. Next, last topic is World Meteorology Day 2026. Read. Okay. World Meteorology Day is celebrated on 20th May 2026, the theme being Building Trust in Policy Making. So what is meteorology means? First and foremost, I'll tell you, it is the science of measurement, weights, okay. So why is it in news? World Meteorology Day annually is observed on 20th May, okay. From when or for what reason are we observing this day? When Meter Convention in 1875 was signed in Paris for your SI units, okay. So this is for your weights, measures, etc. This was initiated in 1999 by CIPM, which is International Committee for Weights and Measures, okay. The theme is Meteorology Building Trust in Policy Making, and India will be hosting the 61st CIML in New Delhi on your 2026 October. So, what is meteorology? It is the science of measurements. Why? So that there is uniform standards, okay, in units and instruments. Where do we use it largely? In navigation, construction, medicine, environmental monitoring, right? And also it is used in food processing, industrial production, scientific research, trade and commerce. So there is a difference between meteorology and legal meteorology, okay. Meteorology means it is a scientific measurement system where focus is on accuracy and standards of the weights and system. This is a physical constant basis. It is based on international SI units, which is also utilized in your research and innovation. Whereas if you see legal meteorology, it is for regulation of weights and measures for ensuring fair trade, consumer protections, these kind of aspects, okay. Now, if you see how the meteorology or the concept of weights and measures have come in, it's been there since very long time. We can trace its origin back to your Indus Valley civilization, okay, where we see so precise weights, okay, where you have cubical chert weights in your Harappa and Mohenjo-daro. We even see ivory scale in Lothal, shell scale in Mohenjo-daro, okay. We also have a bronze measuring rod in Harappa, right. Now if we go to your period of Mauryan periods, we have standard weights and taxation, okay. So there was a good precision in commerce. Then we see during your Shesha Suri, where he brought in the rupiah based on your standardized currency. This was the predecessor to modern Indian rupee. So this brought about uniform measurement practices, and this was very helpful in trade and commerce. So if you see, trade, let's say the weights have been based on different kind of things. For example, rati, it's like seeds, okay. These have been used to measure your gold and gems. Masha or tola, which is again used for your measuring of precious metals. Seer, month, candy, all of this are used for your measurements. So which will aid in trade and commerce, okay. I'll look at this. If you see, how has the evolution been? 1956 we adopted metric system to align with SI units from a standard of weights and measures act. Then we in 76 we started standardization of numerals, regulation of interstate trade. Then 2009 we bought legal metrology act for compliance for packaged goods, right. And then 2023 to 26 we bought about this Jan Vishwas Act. One important thing about Jan Vishwas Act is, if you are a MSME, okay, earlier whatever used to be called as offences, criminalizing offences, now it is brought under decriminalizing offences if you don't follow the proper weights and standard, but rather you will give aspects such as monetary penalties instead of imprisonment, so that your MSMEs will have time to correct themselves, right. So this is based on your improvement with respect to your Jan Vishwas Act of 2023 to 26. So if you see, there has been a lot of your digital initiatives also. with National Physical Laboratory, which acts as the custodian of national measurement standards. And we also have regional reference standard labs for state verification, and EMAP portal, okay, where you can do online registration just to aid your ease of doing business. Your Jan Vishwas bill is also one step towards your ease of doing business for your MSMEs. Then is your One Nation, One Time, okay, with respect to the time collaboration. So if you see the Mater Convention, right, it was signed in Paris in 1875. It was established for a global measurement system. Okay. Then we also have scientific uniformity worldwide. This is very important, just so that this is why we are even celebrating Meteorology Day in the first place. Your SI units again is based on your 7 basic units with respect to seconds, times, meters, kilograms. So if you see India's global engagement, it has become the 13th country to authorize for OIML certification. Okay. Now, with this, India also uses indelible electoral ring, that silver nitrate it has, that you will do after your electoral process. And it is hosting the 61st CIML meeting in your New Delhi, like we discussed earlier. We are also thinking for your environmental monitoring equipments. So if you see your NPL, we have been bringing about many changes with respect to your Asia Pacific meteorology, advanced carbon composting, okay, and also certification for export support. All of this falling in line with your ease of doing business, support for your standardization of weights, measures, and units. Okay. So OIML functions, it is International Organization of Legal Metrology. Okay, so model regulation for member states, global harmonization of laws is something that we do. BIPM on the other hand is International Bureau of Weights and Measures for custodian of global SI standards. Right, it facilitates technical cooperation and promotes measurement traceability so that they are uniform. So if you see what are the significance from your economic perspective, it facilitates good global trade and practices, reduces technical barrier and supports MSME exports, especially this coupled with your Jan Vishwas bill. Okay. Then this brings about transparency, consumer protection and accountability. Scientific pay, it brings an accuracy in research, innovation and calibration of standards. Now if you see the SDG linkages, it helps in SDG 1, no poverty, SDG 3 with respect to good health, SDG 7 with respect to clean energy, SDG 9 industry and innovation, SDG 13 climate action. Okay, so these are the links with respect to your SDGs. So if you see your meteorology means it is about trade, weights, measures, governance, which we have started from your Indus Valley civilization to your modern times. Okay, we also have this Jan Vishwas bill, which decriminalizes and instead brings about your financial or monetary, okay, let's say compliance to be brought about rather than just mere imprisonment, so that your MSMEs will have time and they will have this aspect of coming on board with this understanding. So this is something that is of a change that we have to observe. Let's see a possible prelims question on this. Consider the following statements regarding meteorology. The Meter Convention of 1875 laid the foundation for international system of SI units. Okay, yes, this is why Meteorology Day is celebrated. Legal meteorology deals with scientific standards of measurement used in research and laboratories. No, this is not what it deals with. Again, like we spoke about, right? Your meteorology is helping out in these aspects, but not in legal meteorology. The International Bureau of Weights and Measures coordinates global meteorology activities. This is correct. India has been authorized to issue IOML certification for measuring instruments. Yes, we become 13th country. So the correct options are 1, 3 and 4 only. Okay, so that completes our today's topics. Any doubts so far? Online class, any doubts?